Good morning, everyone. First case is the matter of Elmer Branch versus Cream-O-Land Dairy. May we please have appearances of counsel?
David Kott, K-O-T-T, McCarter in English, for the petitioner defendant Cream-O-Land.
Ravi Suttaraju of Suttaraju and Tharney on behalf of plaintiff respondent Elmer Branch.
Jacobson.
I'll go. Jeffrey Jacobson, Fagery Drinker, Biddle, and Wreath, on behalf of AMICI, the New Jersey Civil Justice Institute, and the National Federation of Independent Business.
Good morning. Thomas Lindhorst of Morgan Lewis, on behalf of AMICI, New Jersey Business and Industry Association, and the Commerce and Industry Association of New Jersey.
Good morning, Your Honors. Caroline Jones on behalf of Amicus, State of New Jersey.
Good morning. May it please the court. Michael Galpern from the law firm of Javabon Wargaft on behalf of Amicus, New Jersey Association for Justice. Thank you.
Good morning to all counsel and welcome. Mr. Kott, please go ahead.
Thank you, Your Honor. Your Honor, may I reserve 3 minutes for rebuttal?
Yes.
I want to start with what the uncontroverted facts were before the trial court. 3 different employees on 3 different occasions over a 10-year period made a complaint that they were not being paid proper overtime. All 3 complaints were fully investigated, and there were 3 decisions. All 3 decisions were made by employees of the department who were fully authorized by the commissioner to make the decisions. So there were 3 decisions, all in writing, and they all found the same 2 things. First, that Cream-O-Land was a trucking industry employer, and second, that it was paying the proper overtime wage. The statute we're talking about is reproduced at pages 6 and 7 of our petition. That's 6 and 7. And I want to start with what the statute does not say. The statute does not say, to have the benefit of the good faith defense, that there must be a final decision of the commissioner after a full adversarial OAL proceeding. It does not say that the decision needs to have the imprimatur of the commissioner. And it does not say that the decision has to be a broad policy that applies to all employers in the state. Let me now turn to what the statute does say, and it creates 2 categories for how you have the good faith defense, and I'm going to deal with the second one. The second category says, or any administrative practice or enforcement policy of such department or bureau with respect to the class of employees to which he belonged. Any does not mean final decision after an OAL hearing. Any does not mean imprimatur. Any does not mean a policy that applies to all employers. Administrative practice, that just means a course of dealing by the department. Here, there were 3 different complaints resolved by the department over a 10-year period. Enforcement policy. Here, there were 3 complaints over a 10-year period that ended up with the department not taking any enforcement action. Statute says of such department or bureau, doesn't say commissioner or director. In the first category it says that, but I'm going to get to that. But here it just says department or bureau. And then it says with respect to the class of employers to which he belonged. The 3 decisions were as to a class of employers. The class was a transportation company. So we meet the elements of the second category. Turning to the first category, it says any, and then it's got some things. Ruling, approval, or interpretation. Approval just means permission. We got permission 3 times. Interpretation, we know what that means. The 3 rulings interpreted both the trucking industry employer exemption and the proper overtime wage. And ruling, Here we had 3 complaints, fully investigated, and all 3 times there was a ruling that Cream-O-Land was not violating the law. I would note in the first category, unlike the second, there's not a reference to the class of employers to which he belonged. That only appears in the second. I recognize that the first category uses the words commissioner or director, but at the time the statute was enacted, and I would guess from the beginning of time, commissioners and directors acted through their authorized agents. The legislature would know there is no way that a commissioner or director could deal with every issue that came before the department. Let me just turn for a moment to whether the statute should be interpreted broadly. We recognize that this is a remedial statute. However, the provision we're talking about was enacted to protect employers from the large penalties that could be assessed against them if they violated this law. And we see how broadly that protection is, because the statute at the end of the section says the employer has the benefit of a good faith defense even if the determinations were legally incorrect. And it's interesting the legislature in this provision used the word defense. In other provisions they use the word exemption. Here they use the word defense, and those are 2 very different things. An exemption applies to all employers and all employees across the state. A defense is limited simply to a single employer. Finally, as to the deference that should be given to the opinion of the Attorney General, we believe it should not be given deference for 3 reasons. First, it is an opinion limited solely to a legal issue. What do the words of this statute mean? Second, it is plainly unreasonable. The Attorney General has rewritten this statute for all the reasons I said before. And third, it was first expressed as an amicus in this litigation, a complete and total unfair surprise to Cream-O-Land that had relied upon the 3 decisions. So for these reasons, we request that the judgment of the Appellate Division be reversed and that the judgment of the Law Division be reinstated. Thank you.
Mr. Kott, can you go back to the statute? And I thank you for helping parse it for us. The first category, as you noted, specifies 2 actors, the commissioner and the director. And the second category doesn't contain that specificity. Can the court look to the federal standard, the reasonably prudent person standard, to help better understand and give meaning to this statute?
Well, I think it can, Your Honor. In fact, this is kind of an interesting record. In the Appellate Division, the plaintiffs argued that the court should look to the federal case. In this court, the plaintiff may take a different position. And I will confess, Your Honor, that when we look at all the federal cases, about 90% of them support our position, but they're not uniform. There are some cases that do not. There are some cases that say, for instance, a letter is not good enough. But the overwhelming number of federal cases say on this record, the 3 determinations in writing by the people who made them would be enough under the good faith defense under the federal statute.
Mr. Kott, if we do look to federal law for cases, what is your position with respect to the court looking at the regulations that have been adopted by the Department of Labor for the federal statute? Because there are definitions in 29 CFR 790.18 and .17 that define the 2 categories of terms that you are parsing for us in our statute, and the language matches up fairly closely. Obviously, the federal statute has some specific language that refers to the U.S. Department of Labor, unlike ours.
Yeah, Justice Lavecchia, those regulations have not been enacted by the Department of Labor. So I'm not sure they're meaningful here. The Department of Labor, those regulations have been on the federal books forever. So the Department of Labor in New Jersey could have adopted them, but chose not to. So I don't know that they're that helpful, although
in terms of the federal department, beginning to look at this question, you don't think it's illuminating?
Well, when I look at the federal cases, there is some reference to the regulations, but most of the federal cases deal with this wording of the statute, as I've done here, Justice Lavecchia.
Mm-hmm. May I ask a separate question? I apologize, Justice Patterson, for abusing my time. The statute that we're focused on in New Jersey law, defense to action, that has the good faith defense in it, is in a particular article of Title 34, Article 2. Correct?
Yes, that's
and then
correct.
Article 3 says, as used in this article, Commissioner means Department of Labor or his designee. There's a specific reference there that acknowledges the Commissioner being able to be equated with a designee. Under Article 2, the definition of Commissioner does not have that same language. How important do you think that difference is in terms of interpreting this good faith defense statute that is in Article 2?
Yeah, I see the reason for the question, but I don't think it's that important because we're still coming back to the legislative intent. And again, the legislature could never have intended that the commissioner or director would deal with these three types of problems. In fact, Justice Lavecchia, on this record, I think a literal interpretation of commissioner or director is absurd for this reason. We prevailed on the three occasions. There was no way to take an appeal and go up through the Office of Administrative Law and get to the commission.
That was the question I was about to ask, Mr. Kott. It seemed to me that if you had lost any of those applications, you could have and had an administrative penalty assessed against your client. You could then request a hearing, seek an ALJ's determination, and then ultimately decision by the commissioner. So if essentially through those channels you lost in the first instance any of those determinations, you could get a decision of the commissioner potentially reversing that, and your client would be home free. I assume you agree with that being it. But what I could not see in the statute is how someone who won in the first instance and arguably might have a stronger case than the person who lost before a hearing officer or someone, an employee of the department, there's no way to appeal a win. And so you can't get, and tell me if I'm wrong about this, it doesn't seem to me to be a procedural mechanism for your client to ever get a decision by the commissioner or the director as defined in the appellate division's decision.
I think that's right, and I think that forms one of the bases for my legislative intent. The other thing is, if we got a favorable decision from the commissioner, we would not need the good faith defense. We would have won with the commissioner. So that's yet another reason why a literal application in this instance of commissioner or director, I think, would be contrary to the legislative intent.
Justice Alvin, you're muted.
Thank you. Mr. Kott, could you have sought an advisory opinion from the director or the commissioner on the very issue that is now before us?
The answer is yes legally, and I'm not sure practically. And what I mean by that, Justice Alvin, is, and I'm going to take the current times, with the pandemic, two parts to the pandemic: health, which is the Department of Health, and unemployment, which is the Department of Labor, which is besieged with unemployment claims. So in this time, had an employer sought an opinion I'm not sure that the department would have an obligation to give one, and I'm not sure we would get one.
But this case goes back before the pandemic. We're not talking. This case is going back to 2019. The reason why I asked that question is because the Attorney General's position, and I want you to respond to this, is that the documents to which you've referred were all generated during the investigative and informant settlement stages of the division's enforcement proceedings, and that they were generated by subordinate employees and not, and as we know, not subject to administrative appeal. And that's one of the reasons why the Attorney General's office is saying there was no high-level determination, and that's the reason why the Attorney General is saying that you're not entitled to the good faith defense. So why don't you respond to that?
Sure. When we say high level, I'm not sure what that means. The third one, which
well,
was
start with the beginning. They're saying that these documents are just investigative informant settlement stages. That's what they're saying. And they're saying that this cannot possibly constitute like an administrative practice to which the Department of Labor should be held. Go ahead.
Yeah, I don't see, because we start with the three proceedings where we have two senior employees who, under the statute, have broad powers to obtain information. In fact, if an employer does not cooperate, that's a misdemeanor. They're backed up. They're backed up by the best and largest law firm in the state, and by that I'm referring to the Attorney General. That's their law firm. And they end up looking at all of the facts 3 times and doing a complete investigation and coming to a conclusion that Cream Land did not violate the law. And Justice Alvin, on should we have sought a formal opinion, one of the precepts that this court has said in statutory interpretation is we won't have an interpretation that a ordinary citizen or business would think the statute. We wouldn't have one that is contrary to the interpretation of an ordinary business or citizen. No ordinary business, big or small, whether it's Cream Land, a small company, or whether it's Johnson & Johnson, a gigantic company, would think, well, I've got the 3 decisions. Oh, now to protect myself, I got to do something else. I got to go and get a formal opinion. And I don't think the legislature intended that either, Justice Alvin.
Well, I guess one of the issues, and I want your, is whether or not like all Cream Land employees should be bound by one of these like low-level investigative determinations. And I'm looking at 43A, which is an email. It looks like an email that begins "Hi Mark," and that's the way it begins. It's the height of informality. "Hi Mark," and then it's Schrager, the section chief, giving his decision on a case apparently that was like non-contested and it was like over.
Well,
so
no.
The question is like how much weight should be given to that, and should all Cream Land employees be bound by such informal decisions such as that? Go ahead.
Justice Alvin, first of all, the employees, the 3 employees, have a right under the statute to go before a wage referee. So the 3 employees at issue could have done that. They had that right under the statute. I reject that this was not an adversarial proceeding. This, again, I'll incorporate by reference. They have broad investigatory powers. Indeed, their powers are greater under the statute than a litigant would have under our discovery rules. Their decisions of the 2017 is the section chief, worked for 35 years. The 2007 was a hearing and review officer. So these are higher level employees, and they looked at the statute. So I disagree, Justice Alvin, with the premise of your question.
Well, the premise of my question is based upon the position taken from the Attorney General. That's what I was asking you.
Yeah. And again, I'll incorporate by reference what I said earlier about the decision of the Attorney General.
Could a reasonably prudent employer have relied on these three decisions?
I believe they could, but Chief Justice Rabner, I would suggest that's not an issue on the record in this case. In the summary judgment motion as required by the rules, we had to submit a statement of uncontroverted facts to which the plaintiff had to admit or deny. And as to two of the three, the 2007 and the 2017, the plaintiff admitted that we relied upon those two decisions, and they can be found, what I'm referring to, in the Appellate Division Appendix at pages 108 to 110.
Other questions, anyone? Anything you'd like to add, Mr. Kott?
Thank you, Your Honor.
We'll have you back for rebuttal. Mr. Kott, rebuttal? Yes.
On the statement that discovery was incomplete, I think we need to go back to basics. The three administrative findings concluded that we were a trucking industry employer. Under the last sentence of the statute, we are entitled to that finding, even if it was legally incorrect. Therefore, the plaintiffs do not get to relitigate whether we're a trucking industry employer because, and we are, it's clear, but assuming we're not, we would still have the benefit of the good faith defense. As to what the three employees took into account, that's covered again by the statement of uncontroverted facts, again referring to 108 to 110A, where the plaintiff in this case admitted that the first and third were full field investigations. What that means is the Department of Labor actually went out and inspected the premises, talked to employees, and those kinds of things. With respect to Justice Albin's question about this being a class action, yeah, that's what supports us. Class action is enormous exposure for a defendant, and it's particularly difficult for a smaller company. And that's the reason why application of the good faith defense in this case is so important. Finally, and related to the prejudice to our people, my client, if the court adopts the interpretation of the Attorney General, first time stated in this litigation as an amicus, a complete surprise to Criminal-Land, which relied on the three rulings. In this case, any ruling contrary to, on this legal issue should be prospective only, because otherwise Criminal-Land is being treated to great prejudice by a first-time opinion of the Attorney General. Thank you, Mr. Chief Justice.
Thank you.